My name is Ryan Johnson, and I am happy to be here first and foremost. But my name is I'm with my title is the Chief Privacy Officer and Vice President Associate General Counsel of Savvas Learning Company. We are a K through 12 ed tech and online curriculum and print provider. We used to be Pearson K-12. It was divested approximately about 6 years ago, and so we now are a standalone organization. Today, we're going to be talking about children's data privacy, navigating legal and regulatory landscapes. A lot of laws and a lot of regulation out there when it comes to both children's data privacy overall and student data privacy as well. First and foremost, a bit of housekeeping. I'd be remiss if I didn't include that this information is just for informational and educational purposes only. It does not constitute legal advice, and they are the sole opinions and not necessarily reflective of my organization, Savvas Learning Company. So, with that said, we'll go ahead and get right to it. This is an exciting topic, certainly to me anyway. It's something that I do and work with on a daily basis, and I'm super passionate about. And I am excited to share some of the developments and new regulation that is out there affecting this industry. Basically, kind of just giving a kind of a snapshot, a state of the state of where we are with children's privacy legislation, where it ends, and what some of the trends that we're seeing right now. The overall trends have expanded age coverage at the state level, not so much at the federal level, which we'll talk about here in a second. But at the state level, we're starting to see an increase in expanding the age of children. Generally, children have been thought to in the age of the internet as 13 and under, but now we're starting to expand those out to 18 years of age with some of the state regulation that are coming online. We're also seeing some stricter consent rules, more direct consent for teens when it comes to data collection practices. As we probably are aware of, data is extraordinarily valuable in today's society, and much more so even in the past few years with the proliferation of AI and training AI. Data is absolutely gold, so to speak, and so the regulatory bodies are starting to tighten the reins on the use of that data. We're also seeing targeted advertising bans. These are the using personal information from children to be tracked around the internet, whether that's persistent cookies or things like that. We're starting to see a bit more regulation crop up around targeted advertising. And again, some of the regulation that we're starting to see is creating this requirement that privacy and security must be designed by default when it comes to these applications here, making sure that the privacy mechanisms are already in place when you're designing the tools and not necessarily an afterthought once the programs and the platforms have been designed. In addition to that, there are some transparency requirements that are in place, and these include things like and you have to excuse my use of acronyms. I use them quite often, but I make sure I explain them when I do see them. The data privacy impact assessments that they are requiring organizations to perform when enacting a new tool, and that's basically requiring a platform to say, hey, what are the privacy implications of this particular tool or this particular feature or some of the use cases that we're seeing around that. Regulators really want providers to be able to keep privacy at the foremost in the front of their design. And not only that, to be transparent about the use of the data that is going into some of these platforms that are out there. We're also seeing minor and parental rights now. We're seeing a more expansion on parental rights. We've probably all started to see this since GDPR, which is the General Data Protection Regulation in Europe, required, or it gave users the ability to direct what happens with their data. The same thing is starting to happen here in the United States as well, and at the parental and children's level when it comes to the use of some of these platforms to be able to say that this data is yours. You have the right to access it. You have the right to delete it. You have the right to correct it if that is indeed the case. And another area is what we're starting to see is some algorithm oversight, where you'll see these requirements that the design platforms are, or the platforms are designed to have greater transparency when it comes to the underlying algorithms that keep these kids and these users kind of hooked on these sites. Algorithms are everything now, as we know. If anyone who uses social media understands that, once the algorithm starts to learn more about you through the data that it collects, it can be helpful and it can be harmful in the same vein. On the federal level, not a whole lot of movement, unsurprisingly. Nothing moves very fast at the federal level, of course. The COPPA 2.0 was proposed. It passed the Senate. It kind of got stalled out in the House. But it has slowed down quite a bit now that the FTC has put out some additional guidance on what regulations are required or what compliance are required when it comes to COPPA. We'll talk a little bit more about that coming up. But the law being updated, slim chances that it'll pass, but who knows? There is another law, the Kids Off Social Media Act, which limits the social media access for minors. That's been pending. Whether or not it'll pass is completely up in the air. As you know, social media is a very heavily used platform in our country. And not only that, they have some very powerful special interest groups in Washington that, help craft and shape what that legislation may or may not look like. And so it'll be interesting to see where we get on the federal level. The states, as always, are kind of picking up the slack. We've seen some age-appropriate design codes in California, Maryland, Illinois, New Jersey, and Vermont. California was kind of first out of the gate in enacting these age-appropriate design codes, and unsurprisingly, they were sued, and it's been stalled in the courts now as a First Amendment violation. And we don't know where this will land. It'll probably make its way up to the Supreme Court eventually, and it'll decide the fate on whether or not age-appropriate design codes are illegal or not. It's basically telling a provider or social media platform or provider that, hey, you must design this product in a way that is less harmful to children. While, yes, it sounds relatively benign on its face, it does have some First Amendment implications there. We're also seeing a lot of movement at the state level for proposals or laws that are regulating age verification for some sites. As you know, or as many of us know, it's a kind of a honor system, so to speak. If you go to a site that may have adult content, it'll say, "Hey, select that you are over the age of 18." Regulators would like to do something about that by putting in mechanisms in place that can kind of guide and dictate or verify whether or not a person or a user is over the age of 18 or not. There's some exciting and very robust technology out there that could literally look at your face and be able to tell with 99% accuracy your age. However, in doing so, it needs more data, sensitive data, which is biometric data, in order to do that. And so that has been this circular stopgap, so to speak, for this particular law to pass. In addition to that, we've seen some other laws that allow some greater expansion of parental tools and opt-outs, and making clearer disclosures and privacy policies on what information is collected and what is shared with, which we'll get a bit more into here in a second. On the federal level, we like to talk about federal and state student data privacy and some of the AI updates. This is probably most particular to folks in our industry when it comes to education technology and ed tech. They're very distinct. I would say that children's online privacy and student data privacy, if they were Venn diagrams, yes, they would overlap quite a bit, but they are some distinct requirements. And most folks in the educational space, not only do they have to abide by COPPA, but they also have the extra regulatory framework of student data privacy regulation that they must abide by as well. So on the federal level, not a whole lot, as we mentioned. There is an executive order that was recently put in place for advancing AI in education. And all that really did was basically state that the goal of the administration is to expand the use of AI in K through 12 learning, whether that be through curriculum or whether that be through training or AI coursework, or trying to train and prepare the workforce for the future on AI. There's been a pledge out there for participating vendors and platforms to basically sign up to say, hey, we pledge to make sure that we are doing the best that we can to provide resources to teachers and schools in order for the AI training and AI education. When it comes to data privacy litigation, This has been a relatively new area because data privacy has not really been a huge topic in the United States as compared to Europe with the GDPR, as we mentioned earlier. But now we're starting to see a little bit more litigation that is popping up. Most of it has ironically involved some older laws that are still on the books, like the California Invasion of Privacy Act, the Telecommunications Consumer Protection Act. And it kind of revolves around the use of cookies and these persistent identifiers that when a user you goes to your site and this cookie is placed on your browser or your machine, that it tracks you around the internet and it reports that information to a third party. And so the litigation is surrounding two-party recording states that are basically saying, hey, you collecting this information is almost like a wiretap by a third party listening in to you and listening to your conversation. And this has kind of gotten stalled out in the courts. It has not gotten settled. There are a plethora of suits that are out there, and it has caused for somewhat of a thorny landscape. There has been an increase in ed tech suits as well. We've seen Instructure, Seesaw, PowerSchool, Google. Some of it has to do with the unfortunate data breach that happened by one of the larger SIS, Student Information Services provider, earlier this year or late last year, whenever that happened, of course. But in addition, some of it has been brought on by ed tech advocacy groups as well. And it has to surround the use of these like cookies and persistent identifiers that they claim that are tracking children. COPPA has had an update. We didn't pass COPPA 2.0, but the FTC did issue some guidance and some updates that became effective earlier this year in June. That gave parental rights, some things like parental rights and some disclosures around third-party data sharing and expanding the scope of PII. We'll talk a bit more about that here in a second. But when it comes to some of the ed tech trends and student data privacy laws, we've seen some increases at the state level, all the way down to the LEA label, which is local level, the local education administration. Um, Basically giving, or at least the trend has been more scrutinization of the security practices of the vendors that these LEAs are providing their data to. And so we've seen increased cybersecurity assessments, and naturally so, as we've seen these massive data breaches that release millions and millions of records, sensitive student information records out to the public or on the dark web. Understandably, districts have been a bit more cautious when it comes to that, and they have been assessing vendors quite a bit more. We're also seeing some AI use agreements that are starting to pop up where districts, state level agencies as well, that are requiring a attestation, so to speak, by vendors that the data that is being supplied to them for the delivery of their services is not being used to train AI models. As we understand it, this is very sensitive information, and students and school districts, understandably so, don't want student information to be used to train large LLM models or large language models, so to speak. With regards to student data privacy specific regulations, we've seen a little bit of movement. California kind of renamed their student online. It used to be the Student Online Privacy Protection Act, coined SOPIPA. Now that has been changed to the Kids Online Privacy Protection Act. And so what that did was took it out of that education only bucket and made it more broader, that it applied to site operators that are using children's data overall, not just in the educational space. In Virginia as well, we've seen SB 1486, in Ohio, SB 29. There's just a few basic ingredients that go into student, or I'd say most operative agreements that go into student data privacy regulations. And one of those are requiring districts to have a signed data protection DPA, data protection agreement or data privacy agreement, a DPA in place before sharing that data with a third party vendor. And that dictates what that vendor can do with that data, what they can't do with the data, what disclosures they can and cannot make, what security protections that need to be in place as well. And it just adds a bit more security around student data overall. Now, when it comes to student data regulation in the federal laws, um, most of us here, I'm pretty sure, have heard of FERPA through either one way or another. Either when we were a student, we heard about FERPA. Hey, be careful, this will go on your permanent record for the rest of your life. That was FERPA, even back in the day for some of us who are a little bit older. But even now, it's the same. On a yearly or annual basis, parents, if you have children in school, are encouraged or required to sign a FERPA acknowledgement or FERPA disclosure. Most educators have to go through FERPA training, both in the K-12 and in the higher ed space as well. And it governs the privacy of student education records as well. Um, and not only does FERPA apply to school districts or schools or universities, it also applies to third-party service providers that provide that may use an education record in order to deliver services to the school district themselves. And they are under the auspices of FERPA as well. The PPRA, the Protection of Pupil Rights Amendment, is not a, this one is probably smaller, more less known, but it is a student data specific privacy regulation that's on the federal level. And all that really does is gives parents additional rights when it comes to the ability to use surveys um, um, and what information is disclosed in these surveys that students take home. I think in the past, before this was enacted, it was very detailed information they were looking for. Like, hey, Johnny would bring home a survey and say, hey, how much money do we make, mom and dad? And what's our political affiliation, mom and dad? And parents understandably were like, well, hey, this is a bit more information that I'd like to share and not necessarily for educational purposes as well. So COPPA as well, the Children Online Privacy Protection Act, applies to online data collection from children under the age of 13. We'll get into what the nuts and bolts of COPPA a bit more, and that's probably what we'll discuss the most is COPPA as it pertains to children's privacy, because it is the most prolific law on the federal level, of course, when it comes to the protection of children's privacy. But continuing the trend when it goes to student data privacy overall, the Federal Trade Commission has recently issued some guidance, what we'll talk about here in a bit, and then there's the state laws. As I mentioned before, there's only so many. There's just about four or five overall consistent components that we see in state student data privacy statutes, and we'll talk about here in a second. But with regards to the FTC guidance for ed tech providers, FTC, released some updates overall for website operators that are subject to COPPA, but specifically when it comes to the ed tech space, the FTC issued guidance on limiting the data collection than what's necessary for the activity. And so if your product offers a calculator, a fractions calculator, or something to that effect, you probably shouldn't be asking for a student's full name, email address, social security number, or something like that when it's not really necessary for the delivery of your services. Data that is collected via schools must not be used for marketing. And that is something that is consistent with the state level student data privacy laws as well. Targeted advertising and marketing is kind of a no-no when it comes to student data, and that is a hands-off area, both on the state level and now on the federal level as well. They also advise EdTech providers not to use or keep or retain children's data longer than needed. If a student signed up or a child period signed up for just one particular use case, hey, I just want to download this paper, you don't necessarily need to keep that information in perpetuity, and there's really no need for it as well. As we understand now, the cost of data storage has gotten cheaper and cheaper and cheaper over the years with servers moving to the cloud and the lower cost of storage. Understandably, that data is just stored. People store it because they can, and it's cheap to do so. But there has been a concentrated movement to eliminate and minimize that data storage as well. FTC is monitoring ed tech providers when it comes to COPPA to make sure that they are in line. And we'll talk about some heavy fines that have been issued as a result of COPPA violations. COPPA has a lot of teeth, so to speak, and that is one area that on the federal level that these online providers are required to abide by. When it comes to state student data privacy laws, they're generally stricter than the federal laws. As we just mentioned, we've only got three, right? We've got FERPA, we've got the PPRA, and we've got COPPA. There's not a whole lot. And so this is what prompted this proliferation of state student data privacy laws that we saw. I think to date, there's probably about 47 states in the United States that has student data privacy laws specifically governing the use of student data. And what they have is pretty much four main ingredients, right? There are contracts. They're requiring that LEAs or school districts or school administration officials to have a contract, a data privacy agreement, a DPA in place with these online providers in order for them to use that information. And those that DPAs will dictate what you do with the information, how you do it, where you do it, when you do it, and what happens after you've already done it. Security, there's some security requirements in there as well that require minimum standards or security frameworks that are in place to protect this sometimes very, very sensitive information, depending on the nature of your services. If you are a SIS provider, student information service provider, you have some very, 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 very sensitive information, and you must have security protocols in place commensurate with the sensitivity of that information. In addition to marketing, as we talked about, it's a big no-no. Student data and marketing, I mean, it's just an absolute no-go. It's an absolute no-go. You cannot use student information for advertising. It's a shame that we have to tell providers that, but now the state laws are doing that, and I'm sorry, the state laws have been doing that, but now on the federal level, it's being done as well. In addition to that, there's some parental rights that are involved that parents must have access to the student data at any given time. The parents own the data. The data is not owned by the ed tech provider. Um, what is the main differences between FERPA and COPPA? There are some key differences and there's a lot of overlap as well. As we mentioned, FERPA protects the privacy of student education records, whereas COPPA protects the PII that's collected online from children under 13 overall. And so you've got the two spaces. You got the commercial space and then you've got the student education space. And some operators do both. I mean, if you think about Google, for instance, they have Google Classroom, Google Education, but they also have YouTube. They also have other areas that attract children as well. And so there needs to be regulation in place that protects both of those. It applies to obviously school districts, but COPPA applies to websites. And consent is required. Under FERPA, there's that written parental consent that goes out each year. Under COPPA, there's that verifiable parental consent that must be there. Sometimes consent is not necessarily needed when it comes to the ed tech space, so to speak. So a school can share data with an ed tech provider so long as there has been a written agreement that usually goes out at the beginning of the year that parents give that permission to. The same with COPPA. School districts can act as an intermediary and consent on behalf of parents in the space of COPPA, but the requirements are that that information that is shared with that provider is only for educational purposes for no other reasons whatsoever. So they don't always need to collect the COPPA consent, school districts separately or together. I'm sorry, sometimes folks or districts may think that, oh, I've gotten FERPA consent that also supplies COPPA consent. We advise that err on the side of caution and both get COPPA and FERPA consent from individual parents. A quick overview of COPPA, just an extraordinarily high overview. It was enacted in I think the year 2000 or the early 2000s, and it protects children under the age of 13 online. It broadly applies to two categories, whether the site is directly directed towards children. Think of a Nickelodeon.com. I don't know if Nickelodeon even still exists, but it did when my kids were young, or even when I was young. And so if kids are going there specifically, COPPA directly applies. But think of a Facebook or think of an Instagram. That site is not necessarily for kids, but it does attract kids. And these mobile apps and connected video games are all within the purview of FERPA, and it governs the online collection of children information, children's identifiable information, and that means can this identify who this child is? Is this Johnny Sanchez? Is this Johnny Sanchez's parents? George Sanchez and Margaret Sanchez, or does it also includes persistent identifier? These are these third-party persistent cookies that may drop on a child's device or a home device and track that information across the web as they start to navigate. Again, it is requiring users to wherever there's requiring users to submit information. If you think about Instagram, for example, if you upload a story, you've just submitted some personal information, which may include location data, biometric data, things like that, and you may get those passive cookie and persistent identifiers as well. Some of the key concepts of compliance, basic when it comes to COPPA, complying with COPPA. Basically, the overarching theme is that children are not old enough in order to be able to accurately consent to something. As you think about now, when you navigate to a website, you get greeted with a host of legal requirements that come in that say, hey, do you accept or reject or consent to the use of cookies or marketing cookies? Or, hey, by clicking this box, you agree and consent to the use of your information for marketing purposes. Children under the age of 13 just aren't, and I'd argue, many adults, probably aren't necessarily sophisticated enough to really understand what these websites are requiring or asking for. And so COPPA requirements are making sure that children understand that. Operators that are subject to COPPA, they must get verifiable parental consent before they're able to use that children's data in order to be able to advertise or to share it with a third party or anything like that. They're requiring more transparency when it comes to privacy policies. Does a privacy policy read like a mortgage document, or is it plain language? Is it easy to navigate and understand what your rights are? And it also gave some guidance on where to put privacy policies and some information on parental access and control. Some of the recent updates that were just enacted and put in place in June of this year requires, expanded the definition of PII, or it basically started to include these persistent identifiers, these cookies, biometric information, photos, videos, audios, geolocation data. All of that is very, very useful data when in the grand scheme of things when it comes to marketing. By having this 360-degree idea of who your users are, you're able to accurately target ads better to them. The FTC updates have basically put all of those things in the bucket of PII. We talked about the opted-in consent for targeted advertising. Parents must provide verifiable parental consent that yes, it's okay for you to send my child some more information on this particular product. We want to limit the data retention. Do not keep it longer than you absolutely need it to. Data minimization. Only collect what you need. Don't collect more than you need. Data security. Do you have some basic data security frameworks in place that the hackers or threat actors can't hack into your site and retrieve all of this information? And also, there is some safe harbor guidance for a safe harbor program that a website operator can join. And by joining the safe harbor program, they are deemed to be in compliant by the FTC. So some additional measures is when it comes to the disclosure of third-party information or information to third parties. Um, Operators and vendors are required to have a contract or an agreement in place. Think of the DPA that we talked about that basically says what you can, what you can't, how you can do it, when you can do it, things like that that dictate what the ability to use that information is for. Whether or not that these third-party vendors collect more information than you are collecting, and whether or not separate verifiable parental consent may be required for targeted advertising. When it comes to ongoing compliance, we recommend that ed tech providers or vendors or platforms in and of themselves regularly review your policies and your practices. You have a privacy policy that was last updated in 2016. It might be time to review that in light of some of the recent changes that have come down. And again, we've got that safe harbor option where if a vendor or a operator joins a FTC approved program, then it removes the direct oversight by the FTC of your organization, and that's something that you can advertise on in your privacy policy, a trust center, so to speak, if you have that, and that signals both to regulators and ed tech or education LEAs themselves that this is a trusted partner when it comes to the use of student data. In 2025, the FTC very well may start publishing a more detailed description of the providers that have signed up for the third-party partnership as well. Some of the enforcement measures that we've seen, some of them are old and some of them are not so old. The YouTube one from 2019, this was the largest, one of the largest, I think. It was $170 million for a COPPA violation. This is what sparked YouTube Kids. I don't know if you are a parent and your child is watching YouTube. basically, there's two different versions of it. There's YouTube Kids where children can, navigate through YouTube, but then there's the regular YouTube where it will require parental consent for a child to be able to use that. In Epic Games, there was a massive fine of $275 million for violating children's privacy and keeping that data for longer than they needed. I think Epic Games was keeping, they probably had information on my kids when they were young and they were playing video games and, from 10 years ago. You don't need that data anymore. Delete that data. I know it's easy to store, but those are some of the enforcement mechanisms. And again, one of the latest was Edmodo, which was an ed tech provider. They were using the COPPA consent that the school districts provided for additional commercial measures to be able to send out ads to a parent and using that parental consent. And the FTC basically is telling them now, and that was a part of the update. They're saying that you cannot use the consent that was provided for educational purposes and then take that consent for commercial purposes as well. Very small and narrow. And as I wrap up here, some of the key takeaways to remember is that these penalties are significant. The FTC is actively enforcing children's privacy laws, and most of your contracts and your policies must reflect that compliant use of data collection and deletion practices. And with that, I'll wrap up. Thank you all. I really do appreciate the opportunity to speak about something that I'm passionate about.